All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is number 21-1182, Florida Bar versus Stephen Rakusin. And I apologize if I mispronounced the name.
Rakusin.
Rakusin, okay. We had a debate in there. Got it wrong.
We had one ahead of time too, Your Honor. Good morning. May it please the court. My name is Kevin Tynan. I'm here on behalf of Mr. Rakusin, or Rakusin, who's also here before the court. There are three actions that were found to be unethical by a referee. The first concerned a March 23, 2016 letter to clients advising of an impending suspension, as well as some transitional issues. A second matter regarding a May 2014 retainer agreement with a client that had a penalty clause in it. And there were remarks, the third matter, remarks about a recently retired circuit court judge with a letter dated August of 2017, which was a response to a bar complaint from that judge. In this case, the bar at trial asked for at least a 1-year suspension. The referee is recommending disbarment. There are two rule violations, Rule 4-8.4c, which is dishonesty rule, and 484d, conduct prejudicial to the administration of justice. There are three interrelated somewhat actions that I'm going to refer to. The first case as the suspension case. That's where my client was suspended for 90 days. That required him to send the notice letter to clients. The second case was a case that was dismissed by this court for a statute of limitations issue, and of course the incident matter that brings us here today.
But before you get there, could I
Sure.
just establish a couple of predicates? How long has your client been practicing law?
Ooh, good question. Did not look, but it's above 30.
More than 30 years. And can you tell me a little bit about your client's prior discipline?
Sure. The big one, the 90-day suspension, and the reporter referee will describe everything, and there's some older, and I want to be accurate, so I'm going to get that in front of me. There's a 1994 public reprimand. There is a 2010 admonishment for minor misconduct, and then the 90-day suspension, which is from 2016.
Okay, so he's been practicing for 30 years. He has been disciplined on 3 prior occasions. And my bottom line question is, on what basis should we have confidence that after such a long career and after just assume we're in the ballpark of the 3 allegations that the referee established below, why is anything other than disbarment appropriate in this case? Why has he not learned from his multiple contacts with the bar that his manner of relating to clients won't do?
I understand your question. And as I was looking, he's admitted in 1974, so add 10 years to
So that's
the
before
process.
I was born.
And before I finished high school. So, in this case, in any case where there's a recommendation of disbarment, I think we need to look is there an opportunity for rehabilitation? And your question goes to that. Is that certainly over his career he's had bumps in the road. The first 2 were minor. The other one that's a little more recent, though still it's 2016, was more significant at 90 days. But if you look at, and I know this court over the last few years has had sterner sanctions, but usually it's gradations of increase.
But counsel, don't we take very seriously failures of a lawyer who has been suspended to get on the narrow path and do exactly as they are supposed to do under the terms of the suspension? I mean, because you're already, they've already gotten themselves ensnared in the disciplinary process. And then we issue orders, and there are rules about how things are to happen. And when that is not followed scrupulously, we take a very dim view of that, don't we? I mean, you can look at that. There are cases that are legion, where someone has failed to do what they're supposed to do when they're under suspension and they're disbarred. Isn't that correct?
Correct, especially if you practice law, which is not an issue here post-suspension. There are lawyers that don't send notices to clients that get in trouble, either enhanced sanction or disbarment if they continue to ignore the court. I think, there's a guy named Norkin, who I'm sure the court's very familiar with, who was in trouble for a lot of things, but he didn't do his notices, and the court says that's the most important thing, is to provide notice of the suspension. Here my client did that, and what the court or the referee took issue with is some of the language in the notice letter. And as you know, under the rule, all the lawyer has to do is provide a copy of the court order. Here, he provided an explanation of why he believed why he took the plea in the case, and provided some transition issues. And it's comments about those transition issues that the referee found were misrepresentation by omission. We respectfully disagree with that. And there were two parts to that in the referee's finding. One, that the referee thought we didn't give clients enough time to decide about the transition. And the transition was simply, if you looked at the letter, I'm being suspended. Everyone that had worked for me, they're now going to work in this new law firm. Same people, same employees, same office, and we're going to send the file there unless you tell us otherwise. And in the letter it said you got to tell me within 2 to 3 days, but what the referee declined to comment on is the testimony in the case that my client had talked to everyone prior to that point in time, or most everyone, I think, is the accurate testimony. So, I understand the concern, but when you look at the letter itself and what it did, from our position, it's not misleading. It's not a misrepresentation by omission. It might have been nice to have included a little more. And I think the gist of the main complaint is that my client, quote, didn't say he was part of the new firm that he owned. And he rebranded his old firm to get his name out of it, so there'd be no confusion. His prior firm had his name in it. He was being suspended for 90 days, didn't want anyone to think he was practicing law, so he had a different generic name for the law firm.
Let me ask you, because my time is short, the retainer agreement.
Yes, sir.
Had a clause that I'd never seen before, and I've been practicing law 43 years. Well, I've been a lawyer 43 years. The clause says the client agrees to pay the bills within 10 days. In the event the client fails to do so, the law firm is specifically and expressly authorized to voluntarily dismiss any pending litigation on the client's behalf, regardless of the status of the matter, at the sole and exclusive option of the law firm. So you file the lawsuit, the client doesn't pay you bills within 10 days, his firm can just dismiss everything. What if there's a statute of limitations or all these other types of statutes that have time limits in it, where the client may not be able to refile? I've never seen that before. And he claims, his testimony was that It's just something he picked up in the 80s, and he's been using it ever since.
Right. Well, when this issue came up, he stopped. But when Mr. Rackison filed his answer to the bar complaint, which is in evidence, when he discusses this, he makes a statement that that clause is not valid and not enforceable. He understood that. He had never in his career exercised that provision. Doesn't mean it was right to be
I
there.
bet he got his clients to pay.
Yeah.
If they pay, they don't use it.
And Justice, I understand how serious that is, but when you look at some of the penalty clause cases like Hollander, there were public reprimands, not disbarments. And I know Hollander's a bit old. I can say that because I prosecuted it and I was still with the bar at the time. I know it's old.
The referees, I mean, he found it to be outrageous and unconscionable, and basically putting his interest before the interest of the client, which as we know, is a no-no in our profession.
Right. It said that on paper, and we can't retreat from that. It did say that on paper. My client did admit early on, not valid, not enforceable, but his critique of the bar's case is that there's no showing that he ever exercised that clause. And they brought in no clients to say they were bullied, intimidated, or otherwise. Doesn't justify that it was there. But that in and of itself does not equate to the disbarment that's being recommended here.
What do you propose as a discipline?
What we proposed is, again, looking at the three acts, trying to balance the severity, recognizing that there is a 90-day suspension out there. At trial, we recommended another 90 days, something with rehabilitation perhaps, some probation, other acts. But if we look at the three finite acts that are here, they're not in and of themselves, or combine the three of them, they don't warrant the disbarment that's being recommended. We believe it's some form of suspension. And again, when we look at some of the prior sanctions, they are dated. And that is something that we look to from time to time. But I understand the course of conduct argument that I'm sure my colleague will be advancing.
Wasn't he suspended in 2016 for 90 days?
Correct.
And so you're suggesting that we suspend them again? Shouldn't there be like an upscale here?
There can be
keep
when
doing the same thing over and over again.
Yeah, there can be. That's not unreasonable. And again, if you look at what the bar offered, suggested at trial, it was a year. So they looked at maybe a step up from the prior. But a step up is 91 days, too. That is a step up because now it requires proof of rehabilitation. There were some other issues, if I could briefly just raise them. And we're going to rely on our brief because I know we all have read those. We did have some procedural issues that we'd ask you to take a look at. First, having to do with notice as to the third issue in this complaint. The only point I want to make on that is the rules require a finding of probable cause. In this instance, my client got, or received is probably the better word, in June of 2020, a letter of advice from this grievance committee in this case that said there was a problem with the retainer agreement and there was a problem with the letter. That's what we all believe were the issues in this case. And as the case came back to this grievance committee and ultimately to the Board of Governors, there was never a discussion of the letter or the responsive letter to the bar that made comments about the judge's, Judge Gold in his grievance. And so we believe that there was insufficient notice to have addressed that. Now, I know my colleague is going to say, well, we don't have to give a bill of particulars. That's true. The bar doesn't have to give a bill of particulars. But if you tell us here are the stories, if you look at the notice letter that's given to us, here are the two things we're concerned about, here are the rules, and then there's this third issue that pops out later, that's not proper notice under the rules, respectfully. There's also endemic in this case a res judicata question. Certainly, we've read the case law. We've both briefed it. And in this instance, the reason we have the discussion of the three cases is because in the first case, Judge Gold did testify. The same exhibits were entered in that case as an aggravating factor. And we agree that it was presented for aggravation. The difficulty, and it's more of a systemic issue for me as a lawyer practicing in this area, is how many times can the bar use the same set of facts to do something? In this case, they use it as aggravation. Under typical res judicata rules, anything in that first case would have been absorbed and forgotten. You can't go back and use it. When you look at cases like Rodriguez, where the court did find res judicata would apply depending on the nexus to what happened before, but in Rodriguez they said old case had these things, and then here it's a brand new matter. But we're talking the same facts. It was in both cases, and I reserve the rest of my time. Thank you.
You're out of time, actually.
Oh,
Use
completely
all
out of time.
but
Okay.
We'll give you 2 minutes for rebuttal.
Thank you very much.
Thanks.
One will do.
Hi. Can I start with a question?
Yes.
So the bar asked that there be a minimum discipline of a year suspension. Could you kind of walk through the bars? I understand now that you're defending the disbarment, right? But when you evaluated it and you assumed that you were going to prevail on proving the violations, why did the bar think that a year would have been sufficient?
And I think perhaps this is a fairly rare case that the referee is recommending disbarment when the bar itself was coming in recommending a 1-year suspension. And the difference perhaps is that we made that decision before the trial and the referee made the decision after the trial. And there were things that the referee got to observe and learn in that process that I think changed his analysis on this. I can go through it. In fact, I'll just start with this now. On the matter about Judge Gold, the allegations there in his answer to the bar's complaint, he directly puts in that this judge committed a violation of Canon 3 subpart 7 because he had ex parte communications, and he left out of his explanation that there is a subsection C in that rule that allows judges to talk to other judges and their staff about cases, while he had one other one in there. And of course, Judge Gold responded in a rebuttal shortly thereafter and in detail explained that no, he hadn't violated the canons, and showed Mr. Rackison the subsection that he'd overlooked, and Mr. Rackison did nothing. Now, if Mr. Rackison had responded back to the bar with an oops, I missed this, it probably would have been a nothing. But instead, he hunkered down on this judge should be the one in a JQC proceeding rather than me in a bar proceeding because he violated this. And when we came to the complaint and we filed this, and I can explain the jurisdiction on that later, but when we filed this, he didn't first claim that there was no jurisdiction. He filed a motion for summary judgment and an affidavit, and in paragraph 68 of the affidavit, he once again claimed that the judge improperly violated Canon 3 with no explanation at all about subsection C.
So the bar basically, I mean, if the thing that jumps out from the record is this retainer thing with the, to pay me in 10 days or else I can dismiss your case. Standing alone, the bar's position would be that wouldn't warrant disbarment, even though that, I mean, it seems like that's kind of an unprecedented thing. None of us,
It's a very unprecedented thing. As he makes the argument, we didn't have proof of a client that he had actually dismissed the case. And so when you get to that factor in mitigation and aggravation, I think the bar was hesitant to go farther. But what happens with the referee is when he sees Mr. Rackeson's demeanor in front of him and his continuation to basically just lie about Canon 3, that things changed with him. So we made an argument at the end for 1 year. We submitted a proposed ROR for 1 year, and this judge said, no, I don't think that's right. Now, this is an experienced judge. It was an experienced prosecutor, and he got to spend several days with this man watching his demeanor. This case in some ways reminds me of this court's problems in Kinsella. In that case, you had a young woman. She had not shoplifted, she'd stole from the till when she was in law school and working at a retail store. Petty crime, two-bit thing. Except this court was very, very troubled about the signs about her core character that show up if you're going to steal from the till in a job like that.
But we suspended her, didn't we, for 3 years?
For 3 years.
Right.
You did.
So part of my difficulty on the sanctions front is you've got Kinsella, you've got Altman. Those are not disbarments; they're long-term suspensions. Right. And then you've got Kupke and you've got Strems on the other side, which do result in disbarment. And it seems like one distinguishing factor is experience. And maybe another is, I mean, to sort of try and put a word around it, recalcitrance or not altering, course.
Yes.
I'm wondering if you can help us situate this case between Kinsella and Altman and Kupke and Strems.
And you're right, it was a 3-year suspension, and the fact that she was young and the fact that I can't say he's old because he's about the same age. But he's very experienced. How it does play a factor here. But also what we're seeing through this series of things are misconduct where he's more interested about running his business and how he makes money from the fee structure than he is about servicing his clients. You see that in the letter he sends, his so-called exit letter. You see that in spades in this retainer agreement. And even now when he's fighting with Judge Gold about these things, wanting us to be a JQC rather than what it is, there's a pattern in there that's very troubling. And just as this court saw the character issue in Kinsella, I think this referee saw a character issue here and came to the conclusion that what he was seeing was something that couldn't be rehabilitated in a year. He apparently didn't think it could be rehabilitated in 3, and that's why he's not recommending a permanent disbarment. He's recommending one from which reapplication could take place, although Mr. Rackeson and I are probably old enough it would be hard to do that. But I think that is what's going on with this referee. Now, I will tell you that is a big jump up from 90 days, which is the last suspension he had. But, I just this morning met this man, and I'm not going to tell you that I've got the ability to second guess what the referee did. You all clearly do have the power to second guess him. And so the bar is providing this information to you, hoping that you will have the information you need to make an appropriate sanction. But in that process, I do hope that you will give due regard and consideration to the referee's recommendation, because he was there and spent the time and made an assessment of this as the person on the bench. And I think that is warranting consideration. I think it's pretty obvious, jumping to a couple quick issues here, that res judicata doesn't apply here. These things weren't brought as a cause of action in a prior proceeding. So unless there's any questions on that, let me jump quickly to what he has talked to you about. He was entitled to a notice of finding on the Judge Gold one. That is an extremely complicated set of issues that would take me about half an hour to talk about. But what I will explain to you is that he's not claiming that he had a due process violation, that he knew nothing about this and it came as a surprise. I mean, he had lots of notice. It came up in the former bar hearing. He knew that response from Judge Gold was in the packet that was sent first to the Grievance Committee and then to the Board of Governors. So this is not a due process, oops, I'm surprised I didn't know about this. What he's actually arguing to you because it's a motion that came late, is a motion for involuntary dismissal because you and the referee lack jurisdiction, because it said that the Board of Governors found probable cause that further disciplinary proceedings are warranted. Well, that's the precise language in Rule 3-7.5C7 as to what the Board of Governors is supposed to say when they find probable cause. They just track the rule. There are 3 sets of rules in the row there. What the bar lawyer can do and bar counsel cannot find probable cause at all. He can send it to the grievance committee. They can find probable cause, and when they do so, they give an explanation so it can be reviewed by the Board of Governors. The Board of Governors has the authority to overrule it as it did there. This is a judicial referral, so actually if this occurred today, I guess it would go one more step and you all could review it before any filing. So this process bounces back and forth. It gets complicated. He talks about dismissals. Those dismissals open public records for a few days at a time, but they're not dismissals with prejudice. The rules make it clear it can be reopened. And so none of that is jurisdictional in nature, and he doesn't really have a due process argument on that. Then he jumping, I think, then to the retainer agreement, Judge Labarge is right. This is an extreme agreement that clearly is unconscionable. He has admitted it's unconscionable, admits that it could be violations of several other rules. He just maintains that it can't be a violation of 4-8.4 unless he actually used it. Well, he used it for 30 years with every client that came through the door. And the bottom of that contract says that he makes them read it in his presence and agree that everything in it is hunky-dory. And we have no reason to believe he didn't do that since he represented that. And this is a matter, again, of a lawyer who is throwing his authority over his clients in a fashion repeatedly. And I mean, in terms of the administration of justice, starts and often ends in relationships between a client and their lawyer to achieve the client's objectives. And when the lawyer is threatening them, if you don't pay me in 10 days, I'm going to dismiss your lawsuit. The second option, by the way, was I'm not going to dismiss it, but I'm not going to do any work on it at all till you pay me. So the second option wasn't much better. That, in my mind, is a clear violation of that rule. The exit letter, I know he believes the first 2 paragraphs are just his opinion. It sure reads like he's explaining something about the suspension he got that isn't in what is in the terms of the consents and the stipulations that he signed in that agreement. But one way or the other, this is not Mr. Strems, by the way, who just changed the name of his law firm. He created a whole new law firm, and he basically transferred his whole practice to that law firm, and put Mr. Amir in charge of it, and then sends his clients this letter about, this new firm's taking over, and he doesn't say he owns it, doesn't say Mr. Amir is involved in it. He identifies 4 lawyers in that law firm without saying that they were lawyers in his firm, and those aren't the names on Mr. Delbrook's contract, at least, and tells his clients they've got 2 days for them to affirmatively say no in a letter that would have taken more than 2 days to get to them. And he sees nothing wrong with doing that. To be clear, you have a duty under the rule, I always get these numbers, 3-5.1H, to send the notice of suspension. All you have to do is say, here's the notice of suspension. But he went on with this letter that does all of these other things. That same rule in subpart E says that you have 30 days to shut it down and you need to protect your clients in the process. He protected his business. He set this up so he wouldn't lose his clients and he wouldn't lose the value of his work in process by essentially selling this to his new law firm and telling his clients that they had 2 days to do this. And that is also not looking out for the interests of your client. It's not it's making misrepresentations to them, it is a violation of 4-8.4. Now, again, maybe we underestimated what the sanction should be for this, but someplace between more than a year and disbarment, this case deserves an appropriate sanction. You know, you all know, but the people behind me don't know, that the practice of law is a privilege. It's been a privilege for me to stand at this podium every time I've been here, and I started this in 1977. And I believe that this man has lost the privilege to practice law. So unless there's any additional questions, thank you.
And as I ran over, I'll be brief. I want to respectfully disagree with my colleague. The notice issue is about due process. There's an opportunity to be heard on an issue before an action is taken. The notice letter to the clients, the lawyers that were referenced there were the same lawyers that worked in the old firm. And it was to tell the client, nothing is changing except I'm not going to be here for those 90 days. I want to talk about sanction ever so lightly because the question that came from the bench had to do with the two cases heavily relied upon by this referee. Altman is a repeated violation contempt case that equated to a 3-year suspension. Kinsella is a theft case, although it's a small amount of money for a young lawyer, but it's a theft case. They're different. And they were 3-year suspensions. In one of the retainer cases, I think the first one, the referee come in at disbarment, and both sides were appealing down, but when they looked at the cases relied on the referee, they had no nexus to what the violations were. And here, Altman and Kinsella don't have that nexus. Strems was raised as a comparison. When you look at Strems, depending on which of the Strems cases you look at, it's repeated misconduct all across the state. Here, it's 3 new isolated acts. Thank you, and it's always a pleasure.
Thank you very much. Our next case is number 2268, University of Florida Board of Trustees versus Carmody.
May it please the court, Christine Davis, on behalf of the petitioners. The issue before this court is whether Florida's district courts of appeal have certiorari jurisdiction to review a trial court's order denying a motion to dismiss, a defendant's motion to dismiss, when the plaintiff has failed to corroborate his medical malpractice claim with a statutorily qualified pre-suit expert. It's important to note at the outset that the case is not about the jurisdictional irreparable harm component to certiorari review. That component has long been established by decades of precedent in this court. It wasn't impacted by this court's decision in Williams, and it's not disputed by the parties in this case. That's because the legislature has set out a clear and unambiguous process that medical malpractice litigants are to follow in bringing their medical malpractice claims. The legislature has made clear that in the Act, the pre-suit investigation of medical malpractice claims is mandatory and applies to all such claims. These pre-suit investigation requirements are the hallmark to the statutory framework. So the legislature enforces these unambiguous mandatory procedures through several statutes. First, the Act says that no action shall be filed if the plaintiff has not complied with the statutory requirements of the Pre-Suit Act. This includes obtaining a corroborating expert affidavit from a qualified expert under the statute. When a complaint has been filed, but the plaintiff has not complied with the mandatory requirements, the statute expressly says that the claim shall be dismissed.
In determining whether or not that compliance has happened, however, it seems like while the 2013 amendments strike Section 14, which used to limit on its face the power of the trial courts to disqualify or qualify an expert witness on grounds other than qualifications in this section, it does seem that what is retained is the court's ability to strike an expert on the basis of qualifications, specifically whether or not the expert is of the same specialty. I guess my question is, do you agree that the determination whether a physician or medical practitioner is of the same specialty is a determination of fact? That is a question that the court would take evidence on one way or another, and that its conclusion on that front, whether someone is or is not in the same specialty, would therefore, whatever it is, either way, if it's supported by evidence on that, not be in clear violation of the law, like a departure from the essential requirements of the law, which is more cert in how it sounds. Like if it is the kind of question that's amenable to taking evidence, then I think you have an uphill charge on saying that it's appropriate for relief on cert, don't you?
I don't under these circumstances. So starting with whether it's a fact finding, this court in Morris versus Muniz made clear that when you are looking at whether a pre-suit expert is qualified, you look at the evidence of the pre-suit expert's qualifications, which could be his affidavit, his CV, deposition testimony, and you compare it to the statutory requirements and see if they align. So when you get into saying, especially in the medical malpractice context, it's fact-finding, and so no certiorari petition should ever be granted when there's fact-finding. That's not so in a medical malpractice case, because the statute has clear mandates, section 766, 102, 5, and 6 have clear mandates that must be followed for a pre-suit expert to be qualified. So there's no weighing of evidence, there's no discretion of the trial court anymore. The analysis is simply, what do we have that says that on the qualifications of this expert, and do they align with the statutory requirements? And that's what this court said in Morris. And Morris was an appeal from a final judgment, but the analysis is the same.
I think, let me press you a little bit on this. Is it fair to say that there are already out there in the state, there are matters in which two cardiologists or two critical care physicians are in fact in the same specialty? Isn't that being litigated right now? Or is that just not litigated?
It can be litigated if a plaintiff files their claim and corroborates their claim with a pre-suit expert affidavit from a cardiologist, and then the defendant is a cardiologist, then that would be a same specialty. So that doesn't mean that a defendant doesn't challenge it or move to dismiss because they have other grounds for believing that the statutory requirements haven't been complied with, because those aren't the only ones. But it is litigated, and the purpose of the irreparable harm that's clearly established in our law is that you're not supposed to, a defendant is not supposed to have to litigate.
I'm not talking about that. Let's leave to the side the fact that we agree irreparable harm. This statute on its face seems designed to avoid, and in fact does in its textual content, avoids the irreparable harm of ever having to deal with the claim. We agree. I'm focused more on the essential departure from the essential requirements of law part of the analysis. And what I can't seem to get my head around is I'm certain that two ICU physicians, two critical care specialists, will have slightly different resumes, slightly different CVs. Maybe they are hospitalists as well, or maybe they, are internal medicine, heavy ICU docs, or maybe it's a pulmonologist who's also an ICU doc. Folks are going to litigate whether or not those are the same specialty. And I have a hard time understanding how a decision you don't like or that you do like that happens within that context departs from the essential requirements of law such that cert relief is appropriate.
Well, this court has made clear in Kaklamanos and Nader versus Department of Highway Safety, what is a departure from the essential requirements of law? What are clearly established principles of law? And a statute is clearly established law, and the violation of a statute is a departure from the essential requirements of law. So when the statute requires that you shall comply with these statutory criteria or else your claim should be dismissed, failing to do so is a departure from the essential requirements of law.
So that basically collapses into just a straight up kind of merits determination. I mean, to the extent that the whole essential requirements of law and clearly established law, to the extent that that's trying to sort of narrow the inquiry and make it different from just a straight up, did the judge get it right or wrong? I mean, it seems like you're collapsing that.
Well, I'm not. So in a typical case, you would have the expert's qualifications and the defendant. In this case, for example, we had a neurosurgeon who completed the procedure, and they brought a claim against the neurosurgical ARNP. They corroborated that claim with a internal medicine outpatient doctor who had not been practicing in a hospital within 3 years, and through his testimony, which we laid out in his brief, had absolutely no experience with the clinical practice of a neurosurgical ARNP, had never supervised one, had never dealt with, he could identify a wound abscess, but he couldn't treat it. He referred those out. I mean, this is the typical case of these two experts, or this pre-suit expert does not satisfy that requirement. And so then going back to Morris, which I think is critical, is you just consider whether they align. And it is unique in medical malpractice cases because of the way the statutory scheme has been set up.
Counsel, can I just ask you this? When we're in cert land, there are always going to be wrinkles. And one of the things that strikes me about this whole body of case law, there's so much time spent arguing about whether the cert requirements are met and all that. And it seems to me that your argument about the legislative scheme and what the legislature is trying to accomplish really points to the conclusion that there ought to be a right of interlocutory appeal. I mean, then we cut to the chase. We cut to whether the statute is actually being followed by the trial courts, and I think most of the time they will, but we know sometimes trial courts make mistakes, just like sometimes appellate courts make mistakes. And so that would be the clearest, most direct means of focusing on what the legislature is trying to accomplish. Now, what am I missing when I say that?
Well, you're not missing anything, and we certainly, if Rule 9.130 were amended to allow an interlocutory appeal from these decisions, that I think would make sense. But that doesn't help us in this case or in all of the cases that have happened before or the cases that are coming down the pike now. And when you get into the requirements of certiorari, we know there's irreparable harm. so we know there's jurisdiction, and we know that requiring a party, a defendant, to go through the trial when they're not supposed to have to go through the trial in the first instance because the statutory requirements have not been followed, that's irreparable harm. So then you get to the departure of the essential requirements of law, and without having cert immediate review of an order that says denies a motion to dismiss because the court thinks that the experts are qualified, without immediate review, you're gutting that portion of you're gutting the entire act, really, because any pre-suit qualification that has not been satisfied can't be remedied on a post-judgment appeal.
Doesn't it? I mean, it seems like some of the argument between the two sides, though, comes down to whether it makes sense just to have a prophylactic rule, because in the sense of not allowing cert, because you kind of posit the sort of worst case scenario where it's obviously wrong, in which case you would hope that the trial courts would get that right most of the time. You know, that it would be an outlier where you've got people in two, like, obviously sort of categorically different specialties. And then in the case where it's kind of debatable, and maybe an appeals court would think that they would, you know, that looking at it de novo, they would have applied the statutory criteria differently, then you're really depriving the departure from the essential requirements of law element of having any force. I mean, you're basically just, you're either going to have the district courts consistently saying, well, maybe it's wrong, but it's not really wrong or obviously wrong or a miscarriage of justice. And so what's the point?
Well, I think that's where you're getting into where the courts start talking about mere legal error and not simple error. And I don't think that that applies in this context under this scheme, because it can't be a simple legal error or a not serious error, fundamental error, if your pre-suit expert is not qualified. If you haven't corroborated your claim with a qualified pre-suit expert, then you haven't complied with the provisions of the Act. And that requires, under the express language of the statute, that the case shall be dismissed, and it's established that it cannot be remedied on a post-judgment
Yeah, but
appeal.
the clearly established, I mean, that would have to relate not just to the words in the statute, but to the application. I mean, it's going to be rare that there's going to be precedent that directly addresses to, you know, a dispute over a particular expert that's so much like a clearly established case that, you know what I'm saying? I mean, it really does seem like you're essentially turning it into, you know, you're letting the irreparable harm piece, where your argument is obviously strong. It's obvious that, you know, if the whole point of this is to give people the ability to do a proper pre-suit examination and to not be subject to suit at all if the criteria aren't met, it's obvious there's irreparable harm. But if if the other prong is going to have any meaning at all, it seems like what you're arguing for is just a straight up review by the appeals court.
Well, I think that let me give you some examples of why that would not be true. But in the circumstances of having a qualified pre-suit expert, it is true, because that's the law in the statute is clearly established.
Well, but counsel, I just think that's not so. Because, you know, and I realize we were operating under the amended statute, and there's some, I think, greater clarity and it's limited scope, but there's still circumstances under the statute where a determination has to be made concerning whether the expert has been engaged in the active clinical practice of or consulting with respect to the same or similar health profession as a health care provider against whom or on whose behalf the testimony is offered. Well, they're all kind of like a vague, well, however you want to describe it. There's going to be, people will reasonably disagree about some of those things, right?
Right. But
and so I don't know how you can say that just kind of as some clear-cut principle of law that, you know, that we're going to that will be amenable to the kind of treatment you're talking about under the cert standard.
Well, so under the cert standard, when the court is the one who has to make the determination of whether the pre-suit notice requirements have been satisfied. It's not a jury question. It's not, the court has to make that determination. And so when it does that, it looks, and I keep going back to Morris versus Muniz because I think that's the most helpful way to describe it, is that the court has to be able to decide. And so you looked, have they practiced in the 3 years preceding this incident? In this case, no. His testimony made clear that he did not. And if do they practice in the same, or has he had an active clinical practice in the same or similar health profession? The evidence here is that he hasn't. So basically what you're taking is the evidence and you're comparing it to the statutory criteria, which you have to do. Otherwise, it would be rendered, you'd be proceeding with pre-suit because you would have no immediate review when you clearly haven't complied with the statute. And the one thing that I'll just note as far as a prophylactic rule that you always get to go up, there are circumstances where the court has held that it wouldn't be a departure from the essential requirements of law when the law is not clearly established. And so, for example, in the Neves case, it's a 3rd District case, the issue was whether a court was required to hold an evidentiary hearing. Well, the law is not clearly established in the Medical Malpractice Act as to whether an evidentiary hearing is required. Since it wasn't clearly established, the cert petition was denied. In the Mertza versus Tromley case, they made an argument that one particular defendant wasn't noticed properly. And the law was not clearly established. His practice was noticed, and the law was not clearly established as to whether this particular defendant needed notice. That wasn't sufficient for cert review because the law wasn't clearly established. In this case, you have clear statutory requirements that say that an expert has to be qualified. If an expert is not qualified, you shouldn't have to proceed with the act. And so it is unique in a medical malpractice scheme, and with under any subsection other of 5A, B, C, or subsection 6, that you take the qualifications and you compare them, and that's what the courts have to do, and then you have to have immediate review of that. I'm well into my rebuttal, so I'll wait if you get tricky.
Thank you. Adam Richardson on behalf of the respondent. I think the positions have been clearly stated in the briefs, so I'm going to just run through a quick summary of what our arguments are, because I think one of them hasn't received attention so far. The first argument, of course, is that the court should approve the result but not the reasoning of the First District's decision. In this case, I think we all recognize that the courts do have, the DCAs do have cert jurisdiction to be able to review these issues, and the question really is whether it's a clear departure from the essential requirements of the law. Additionally, our second argument is that the 2013 amendments, which are primarily deleting the similar and the specialist subsection and the deletion of subsection 14, which I believe one of the justices, Justice Curiel, might have mentioned, do not undermine Williams, which was based on just general cert principles, which the first DCA recognized, I think, correctly.
I'm glad you brought up Williams because I have some questions about it. In this case, unlike Williams, am I right that there has already been an evidentiary hearing on the pre-suit experts' qualifications?
Yes, sir, that's correct. I'm not sure if it was clear in this court's Williams decision, but it is. Okay, so there were two affidavits.
In Williams, the court concludes no cert but remands, and it says hold this evidentiary hearing and find out, basically. Here, we are, if you will, net of that evidentiary hearing already, right?
Yes.
Okay. Does that limit the applicability of Williams to our case from your perspective?
Limit in what way?
Well, I think there's an argument to be made that Williams, an argument favorable to your client, that Williams constrains us in this case. And then there is a counter-argument that Williams is actually quite distinguishable. It deals with different questions, a different fact pattern. I guess my bottom line question for you is Williams very much help to you today or not? And if so, how does it help you?
I think it is helpful because if you have an evidentiary hearing, then it implicates certain standards of review, and especially the standards of review particular to cert cases. But I think that one of the problems with the remand instruction in Williams, and I don't know how directly relevant to your question is that on cert, the DCAs don't have the authority to issue remand instructions like that. They don't have, jurisdiction is not transferred from the circuit court to the DCA. So I understand that's part of the court's decision, but I'm not sure how helpful it is in saying whether or not Williams applies to our case. But the bottom line is that Williams had a much broader ruling than whether or not an evidentiary hearing was required, and if not, or if so, the implications of that. As the First District said, Williams involved just general cert principles, as I said earlier, which is the clearly established, the departure from the essential requirements of the law, which this court has defined over the decades as a violation of a clearly established principle of law resulting in a miscarriage of justice. And so I think that's what you need to look at there instead of particular procedural distinctions.
Can you, I'm wondering if we need to just kind of rethink how we do cert in the context of where it's coming from a trial court decision on a discrete issue to a DCA, because, just based on reading everything here, it seems like this essential requirements of law test, which is very sort of due process focused, miscarriage of justice, et cetera, it arose in the context of basically a second appeal where, you had a county court does something, circuit court does an appellate review, and then the question is it so bad that we should actually give someone 2 bites at an appellate apple? And in that context, that sort of test might make sense, but here, it seems like the focus is, this whole irreparable harm concept is doing most of the work, and then we get into these weird discussions in cases about the difference between something that's, wrong versus, obviously wrong, and et cetera, and I'm just not sure, whether we're even kind of down the right path on that, or if the question shouldn't be more tied to the sort of, the value add of appellate review, of, this kind of intermediate review or something. I mean, in which case, it seems like that sort of a test, maybe, in this case where there's going to be a lot of disputes about how to apply the tests and everything, arguably there's really just not much value that's going to be added by kind of interrupting the proceeding to have this review of this interlocutory thing. So do you have any thoughts on that?
The distinction between first-tier cert review and second-tier cert review is something that I thought might come up today, and something I've thought about a lot, but it requires going through very carefully the decisions of this court. But the thing is, this court, and I understand maybe you're inclined to want to revisit that, has not really distinguished between the two when it comes to the merits standard of review. In the second-tier context, I believe the test is violation of due process and departure from the essential requirements of the law. But the language is the same between the first and the second on the standard of review of the merits. And so I think the meaning should have the same. And whether the court wants to revisit that, I'm not sure this is an appropriate case for that because that hasn't been clearly raised and obviously hasn't been briefed. I don't know if this is something the court does, but if that is something you wanted to think about, then maybe supplemental briefing on that would be appropriate.
Well, I mean, but what makes the Williams case is, what makes that case kind of strange is that they basically, and the way I read it is, they essentially said, they sort of drew this distinction between, the procedural part and the substantive part, which I'm not sure that I wouldn't put whether the expert is qualified. To me, that could arguably be a procedural thing. You either have a qualified expert or you don't. And they essentially said, even if there was a departure from the essential requirements of law, if it's in this substantive basket, you can't review it. And that's the sense in which I would describe it as kind of a prophylactic rule of sort of saying we're not even going to let the DCAs sort of go down that path if the dispute is over the substance versus just merely checking the boxes of, did you follow this deadline and is there an affidavit, et cetera, et cetera. And so it seems like Williams isn't really trying to apply the test faithfully either, because you would think that what they would have said is there may be some decisions that are so egregiously crazy, the cardiologist claiming to be an expert on, whatever, that's a departure from clearly established law. But for the run-of-the-mill thing where reasonable minds can disagree, you're just never going to meet that category.
Yes, so I have 2 points on that. The first is when we're talking about Williams, we have to recognize that it's a precedent of this court, which then implicates state versus pool standard stare decisis. And
I think that's debatable, but we can talk about that.
Okay. So then I guess my more substantive response is that we actually said that in our answer brief, that there's a possibility that Williams might not be completely accurate, and perhaps the court could clarify it, which is that in, as you said, the run-of-the-mill cases, cert review might not be appropriate because there's no violation of clearly established law, et cetera, but that there are errors that are so significant that it would result in a miscarriage of justice. And in those instances, which I think would be very few and far between, it would be appropriate for a DCA to intervene, as the cases talk about in cert context.
So then let's apply that to this case.
Okay.
Your proffered expert does what for a living?
At this point, the proffered expert is, I think, more of an internist. He is not a hospitalist within the 3 years.
Okay.
Of
And the doctor or the sort of team at Shen's that you sued, what do they do for a living?
The doctor under whom the ARNP worked was a neurosurgeon.
Okay. So you'd stipulate at this point, wouldn't you, that they're not the same specialty?
Yes, but that's not the provision that is implicated by this case.
I got it. I just want to make sure we can have, and we've had, a very edifying discussion about the cert sort of world and the statute, and that's all great. But at the end of the day, we have a case. We have a case or controversy that we need to resolve. And this case involves, I think, a very clear situation in which the proffered expert doesn't meet the statutory command. Just doesn't, right? So whatever we hold in this case, we're speaking to a case. We're not speaking to a close call here. We're not speaking to an edge case. And so since all we really have to do is speak to this case, why should we do anything more than address the fact that this is a not even close situation where you stipulate that the proffered expert is not of the same specialty, that on its face, it may be the rare case where cert is required, and if it's better for us to deal with this on interlocutory appeal in the future, that's how we'll deal with it in future cases. Why isn't that the right outcome to this case?
I have a couple of responses to that.
I figured you would.
Of course, the first is that in the petitioner's briefing in this court, they haven't asked the court to reach that particular part of the process. What they did is they asked the court to kind of address this more top-line issue that we've been talking about, cert, and then send the case back to the DCA to make that specific determination in this case.
So you've stipulated that they're not the same specialty.
That's true. However, that is not the provision of the statute that applies here. In the briefing in the circuit court, they actually said that it is 5C that applies, saying that in advanced...
Well, yeah, but that's because you're talking about the nurse practitioner who works for a neurosurgeon,
yes,
right? Okay. I mean, I think, in for a penny, in for a pound. If it's not, if your internist is not a neurosurgeon, neither can your internist be someone who, as a matter of his or her practice, oversees a nurse practitioner in the neurosurgery field, right? Okay, so the distinction you're drawing seems to me to be one without a difference.
Well, but they are distinct statutory requirements, and if you want to carry out what the legislature intended...
Well, that's clearly what we're going to do.
No, I understand that, but the statute here that applies is the 5C, and I understand that you're trying to hold a stipulation against us on one part of the statute that doesn't apply.
I'm not trying to hold a stipulation against you. I'm trying to give effect to the stipulation you've made.
Right. But
what
then
is the consequence of the stipulation?
But then we also have to give effect to the stipulation that they made in the circuit court, which is not same specialty provision that applies. It is 5C that applies.
And what is and what's the point? Like what's the effect of that? So what?
There are completely different statutory requirements. They have
Okay, so
completely
walk
different
me
content.
through what that statutory requirement does, given that your proffered expert is an internist who does not supervise nurse practitioners in the field of neurosurgery, and the people you've sued are a neurosurgeon and a nurse practitioner in the neurosurgery field. Let's deal with your statutory provision. Help me out. How do you win this case, given that?
Okay, well,
And could you say, is it under C1, 2, or 3?
I believe it's under C1, sir.
Okay.
Okay. So here it's not as narrow as the same specialty, and I think what we need to do is look at the breadth of subsection 1. So yes, it does say active clinical practice of, but there's also that clause within the commas, or consulting with respect to the same or similar health profession. And I think that reasonable people could actually disagree on whether this particular expert in our case does or does not satisfy that clause.
Was there evidence in the record that your expert supervised neurosurgery nurse practitioners at any point in his or her career?
No, but that is not even hinted at in the statute. There's no requirement of supervision, which I understand is the argument that the petitioners have made. It just says, in at least that clause, consulting with respect to.
Has your proffered expert ever consulted with respect to a neurosurgery nurse practitioner?
Not neurosurgery nurse practitioner.
Okay, it just seems to me like the more facts we get, the worse this gets for you, no?
No, I didn't actually think that it was that bad. I thought in reviewing the deposition testimony and the testimony at the evidentiary hearing that this would be more of a borderline case than one under the more clear statutory language in 5A. And I also would then want to point out that we go back to the CERT standard, which is clearly right. And under that standard, the court has also been very clear, as have DCAs, that even a misapplication of law isn't sufficiently cert-worthy. So I think when we're talking right now about we're really talking about misapplication of law. The judge here applied the correct law.
To understand this factually, the phrase here is the same or similar health profession as the health care provider against whom, so on. So how are you defining this? You're conceding it's not the same, correct?
Yes.
So what is it? What is the similar?
That's difficult because in because in 2013 they did, or in prior iterations of the statute, the legislature had defined what similar meant, and then they took that out, and now we're just left with similar. But I believe in the previous iterations it had been something like involved in the diagnosis, evaluation, or treatment of the particular kind of care that was rendered in the case. So I don't know how far that gets me, and I'll be honest about that.
Well, I don't think that gets you very far at all. I mean, I think that if that would point, based on my understanding of the facts about your expert, that would really undercut your position, wouldn't it?
No, I don't think so, because the particular treatment rendered.
What do you mean then when you say you don't know how far that gets you?
Well, because of it being a prior version of the statute that was taken out by the legislature, I don't know how far we can rely on it, right? But if we were to do that, then it's talking about the kind of care that was rendered. And here I understand that she was in the hospital for neurosurgical procedure, but the actual care here was the postoperative wound care, or even just more generally, post-op care. And I think then that our expert would have been qualified to, qualified under the statute to offer standard care opinion against the nurse, because he does have that experience with postoperative care.
So to bring this back to the CERT issue, though, the DCA felt like it didn't even have the authority because of Williams to go down. This debate is about how obviously wrong was this decision. The DCA thought that because of Williams, it didn't even have the discretion to even look at the issue, right?
Yes.
And so one possible resolution of this is to I guess, change, either, interpret Williams a certain way, or say Williams sort of took the departure from the essential requirements of law off the table for this kind of question. We're putting it back on the table. DCA, you should, apply the test.
Yes, and that gets back to what you said earlier, Chief Justice, about whether Williams faithfully applied cert law, because as the court has made clear over the decades, I mean, it's been very consistent about this, cert is a discretionary remedy. And so, I'll not necessarily play devil's advocate, but I'll take it on your terms, which is this Williams decision created a bright line rule that he said completely removed the ability of the district courts to address this issue. And perhaps that's wrong because it is not a faithful application of the court's cert precedents. But then even if the court were to kind of restore that discretion, yes, send it back, I think, to the DCA to kind of address this on the merits. But as I said before, I think in most cases, the result probably would be the same because of the standard review on the merits in a cert case. But perhaps in these outlier cases, for example, one posited by my colleague, then there would be cert relief. If there are any more questions, I know I'm approaching my time. And all right, thank you very much.
Just like to make 2 points. First, to say that the court applies the correct law doesn't help us in this situation, and we set that out in our brief, because if the court applies the correct law, that means that the court says, okay, well, we look at 766-102, 5 or 6, and we decide whether it applies, and that law is applied, but you could have, again, a neurosurgeon and a podiatrist, and the correct law has been applied because the procedure has been followed, and that clearly can't be the law and is contrary to the statute. As far as Williams, I'd just like to suggest reasons that it's incorrect. We did make an argument that the statute had changed, but Williams was based on two primary reasons. Before I get into those, it did not cite or give any kind of attention to the multitude of case law that existed prior to Williams that found there's a departure from the essential requirements of law when a pre-suit expert is not qualified. So the court in Williams kind of grabbed onto the punitive damages analogy to say that, well, in a punitive damages case, you have to determine whether there's been an evidentiary proffer to show a reasonable basis to assert punitive damages. That's not the same in medical malpractice. That's completely different in medical malpractice cases where you have statutory criteria. It's not this flexible, is the evidence sufficient to allow this claim to go forward, and whether the irreparable harm was the financial worth discovery. Here you have express language that you have to qualify under this act or else your claim has to be dismissed. So that was incorrect reasoning in Williams. And one more point, the court relied on the St. Mary's case, which was not opposite to the issue before the court there. In St. Mary's, the issue was whether the patient had ever been, or whether the plaintiff had ever been a patient at the hospital. So that was a disputed merits issue of whether the patient had ever been admitted to the hospital. That wasn't related to pre-suit. So the two main reasons that the court in Williams made this bright line rule that the First District felt like it had to follow here doesn't line up with the act, is inconsistent with the act, and would basically eviscerate the pre-suit requirements. So we would ask that you quash the First District's decision.
Thank you. And I just want to say the briefing in this case was really great on both sides, unusually good, so we appreciate it.
Thank you.
Thanks. Okay, we're going to go ahead and take up our next case without a break. Our final case this week is Citizens of the State of Florida versus Clark, case number 2294.
Good morning, and may it please the court. My name is Allie Westling on behalf of the Office of Public Counsel, and I have the privilege of representing the citizens of the state of Florida, and specifically the customers of Duke Energy Florida in this matter. I would like to reserve 5 minutes of time for my rebuttal. We're here today because of the Public Service Commission's improper decision to go with their gut rather than follow the law. Despite explicitly finding that Duke's actions directly led to the outage at Crystal River Unit 4, the Commission nevertheless ordered customers to pay half of the $14.4 million in replacement power costs which were incurred as a result of that outage.
Counsel, before you get into kind of the merits, can you address Duke's assertion on the preservation issue?
Certainly, Your Honor. With regard to the preservation issue, OPC maintains that we have appropriately preserved our arguments. We feel that there are constitutional, statutory protections that require, that give this court mandatory jurisdiction over this matter, but at the end of the day, worst case scenario for OPC, if the court finds that OPC's withdrawal of the motion for reconsideration led to the abandonment of the issues, there are serious due process violations which occurred in this case, which resulted in fundamental error. And if you'd like, those due process violations consist of a violation of section 120.57(1)(b) and 120.57(1)(j).
But the first time those were raised was in your reply brief, right?
Yes, Your Honor. However, that means fundamental error allows for raising issues for the first time in the appeal. So that's the situation that we have here.
But typically, I mean, in an appeal, the appellant has to raise the appellant's issues in the initial brief. It's not something that you come up with an argument for relief for yourself in the reply brief.
I think one unique circumstance here is that we came straight from the Commission's order to the Supreme Court. There was no intermediate court or district court of appeal where that issue was brought to our attention. As I said, we maintain that we preserved our arguments, and until the answer brief was filed that contended otherwise, we believed our arguments and continue to believe that our arguments are preserved.
The trouble with that, though, is that you first filed and then withdrew a motion below. Why'd you do that? Why didn't you just get a ruling?
There are several reasons for the withdrawal. Unfortunately, none of those reasons are or could have been captured by the record, so I can't really go into those. But what I can say is that the due process violations that occurred here.
You know, I hear you on the due process front. We've heard that argument, but we're stumbling a little earlier in the discussion, which is assuming we don't go to the last refuge of the scoundrel on due process. It sounds like you're conceding that if you had to do it over again, you wish you would raise these issues in the first instance in your appeal brief, or it sounds like we wouldn't be in this pickle at all if you'd just gotten a ruling on your motion below. And so it seems to me at least like a pretty textbook case of waiver of this issue because you've failed to raise it properly on appeal. Help me out here. Without going to the due process thing, do we agree that on the just like frontline question of whether or not it's been appropriately raised for appeal, it hasn't been?
I don't concede that, and the reason for that is because of the current reading of Rule 9.020 on the effect of a motion for reconsideration. 9.020, I believe it's sub 2, 3, or 2G if I'm not mistaken, says that, it currently says anyway, that when a notice of appeal is filed and there are pending motions for reconsideration, that the withdrawal of a motion for reconsideration, or excuse me, that the notice of appeal is held in abeyance until either a ruling on the motion itself or the withdrawal of the motion. Now, the rule used to say that there used to be a sentence in there that said withdrawal of the motion for reconsideration is tantamount to abandonment of the arguments. The rule does not say that, and when we withdrew our motion for reconsideration, that was not that was not contemplated. We felt that since we had our motion for reconsideration.
But the whole idea behind the requirement for the preservation of an argument is to give the tribunal below the opportunity to address the issue. And in the sequence of events here with that withdrawal, you kind of jumped beyond that, and you had an argument that could have been presented by way of the motion for reconsideration, and you didn't pursue it. And so we're here talking about it when this perhaps could have been resolved at the by the lower tribunal and the commission. So I just think if you're looking at preservation, this just seems like a kind of a classic case of based on the law that's out there in this administrative context, that you've got to raise issues that in a motion for rehearing if you've not had an opportunity to do it before, I'm just struggling to see how you get around that in this context.
Sure, I have 2 points that hopefully will help with that. First of all, nothing about our withdrawal of the motion for reconsideration prohibited the commission from, of their own volition, issuing an amended order or taking their order back and fixing it. And I would also point out,
except you said never mind. I mean, effectively. I mean, why would they pursue something when you've said never mind?
Well, also, hadn't you filed the notice of appeal the same day?
No, Your Honor. The sequence of events was the order was issued on December 21st. Mm-hmm. On January 5th, OPC filed the motion for reconsideration. Okay. On January 20th, OPC filed the notice of appeal. And on January 25th, so 5 days after we filed the notice of appeal, we withdrew the motion for reconsideration. The other thing I would point out as far as how the commission is not harmed by this is that their own answer brief, they didn't raise this issue. They acknowledged the court's mandatory jurisdiction over this matter, and at any point in this...
But mandatory jurisdiction is a separate issue from preservation. We have cases over which we have mandatory jurisdiction in other contexts where if an issue's been waived, if it's not been preserved, it's been waived. So that's a category confusion. And what am I missing when I say that?
I believe that the bottom line is that as far as we stand here today, the commission stands by this order, and they could have even filed a motion for relinquishment from this court if they found that they had erred, and they have not done so. They have doubled down on their position that this order is a good order.
Well, I understand that, but the issue is, well, okay.
Look, I mean, you have an argument that where there's no preservation issue, and you're either going to win or lose on it, I think, which is they had the burden of proof to prove prudence. You're saying that they didn't prove that. That's been in dispute right from the beginning. It's in dispute throughout the whole thing. That's the whole subject matter of the order. That's what this appeal is about. So, I mean, can you focus on that?
Yeah, from OPC's perspective, the issue of the preservation of arguments is not dispositive of the matter of prudence. The issue on the motion for preservation, as I've said, and as are relayed in our reply brief, which again was written after we were first aware of this argument that they've raised for the first time on appeal, if you look at it that way. Once we were made aware of this argument, again, in their answer brief, our first opportunity to reply was in the reply brief. We did so. We laid out all of our issues there. And on top of all of those issues, due process violations are fundamental error, even if arguments are unpreserved. And there are a number of cases, the Pumphrey case and the Verizon case cited in the reply brief, stand for that position. So ultimately, the preservation issue is not dispositive of the prudence issue, which is what we really should be discussing, which is what I hope we can discuss more. The 5 flaws in this order are, again, laid out in the initial brief. But essentially, the first argument is that the commission erred by erroneously interpreting a provision of law, essentially the Cressy standard, which is a Supreme Court case which lays out that, and it's been well established, that utilities bear the burden of proof when they seek to recover costs. And with the Commission's finding that Duke's poor decision-making directly led to the outage in Crystal River Unit 4, but then ordering customers to pay half of those costs is an inappropriate interpretation of the Cressy standard. Additionally, the Commission acted outside their range of discretion. Court must not allow, although the statute says that their powers are to be liberally construed, that does not mean they can eliminate the burden of proof, and this court must not allow them to do so. The, the Commission also acted inconsistent with their prior agency practice. They have never before allocated costs for a single outage event, and they have never before cited mitigating factors for any of those reasons either. The 2009 fuel case, which I cite in the initial brief, stands for the typical case where the Commission takes in evidence, they look at, they weigh the factors, and they determine whether or not the utility met their burden of proof. And they're very explicit about that. However, obviously this order is missing all of that analysis. There's a long chain of cases that precede that 09 and follow that 09 case, which show the Commission's common practice. The Commission also, by introducing this for the first time ever, and after any party could present evidence or argument on it, this concept of allocation of costs and mitigating factors, those mitigating factors aren't even supported by competent substantial evidence. Again, 120 sub 57 1J says that findings can only be made on evidence in the record. And the Commission verbally said they're going with their gut. They don't know what facts to base this on, but they're going to just go with their gut and split the baby here.
Well, the going with the gut was more about the 50-50 split, the decision to make it even, correct? I mean, you would say that there is evidence in the record to support the mitigating factors, that the machine did not operate as it was supposed to when the operator attempted to fix this problem manually.
There is evidence of a faulty relay. However, that evidence is a complete red herring in this case, and there is zero evidence in the record of what percentage of the $14.4 million that failed relay caused. There's also zero evidence in the record of how much of the replacement power cost that continuing to do something wrong causes. I mean, there is zero support in the record of any dollar number to support either one of the mitigating factors. And when you consider that on top of the fact the Commission has never even considered mitigating factors or allocated costs before, this is improper. Additionally, the due process violations.
Let me help me understand the facts, or your understanding of the facts. Is there evidence here to support the conclusion that this adverse event would not have happened but for the occurrence of both the operator error and the relay failure?
On record site 1869, Duke's own witness says that had the operator flipped the breaker at the appropriate time, no damage would have occurred.
Well, I understand. I'm talking about operator error. I'm saying that, okay, we know that operator error happened, right?
Correct.
I mean, I don't think that's disputed. And then but I'm asking about the relay failure, if I've got the term right. If the relay had not failed, is there evidence that would show that the operator error would not have caused the problem?
I believe there are sites in the record. However, when you think about it chronologically, whether the operator properly flipped the breaker at the right time precedes whether or not, and the importance of whether the relay was working. It's the operator's error that is the key to this analysis. The operator.
Well, I understand that's your position, but I think that there's the factual pattern here is there are these two different things that went awry, and both of them had to go awry for this adverse event to happen. At least there's evidence to support that conclusion, and you admit that, correct?
I believe there is evidence that that potentially could support that conclusion. However, when you look at the Commission's own order, they did not have to pick a direct cause. They could have said these two things together caused this outage. They did not do that. They said, in sum, failure of the plant operator to follow written procedures without supervisory approval directly led to the outage at Crystal River Unit 4. They weighed all of those factors. Their order shows them weighing those factors, and then they conclude that the one and only direct cause of this outage was Duke's error.
Well, they talk about two causes, but I think from your perspective, the issue is the burden of proof was on the company to show that they acted prudently. One of the things that they could have proved and that could have been found potentially by the PSC was that it was prudent to rely on this relay. Essentially, I mean, I'm not an engineer or whatever, but it seems like this is a mechanism that's supposed to make it idiot-proof, so that if people just sit there, you know, hitting the button repeatedly, that it's going to essentially make it so that that doesn't cause a problem. And the PSC could have found that between the relay working the way it normally does and the fact that this guy had done this before, that it was reasonable, that it was prudent for them to go ahead and do what they did. But they didn't find that. Instead, when it comes to the actions of the company, which is the only thing at issue, that they were imprudent by not following the procedures, and yet they still gave them $7 million. Isn't that the bottom line?
Yes, Your Honor, and not only does the order say that that's the Commission's ultimate finding of fact on this matter, their own vote sheet at record page 91, they have the Commission, every single commissioner signed that on the day they made their ruling, and there are handwritten strike-throughs of the portions they disagree with. But the only thing that's not stricken through, the part that they unanimously agreed on, is that failure of the plant operator to follow written procedures without supervisory approval directly led to the outage at Crystal River Unit 4. They obviously had a pen. They could have written in and said, and the relay caused the outage. They did not do that. The Commission made a finding of fact, and the only natural conclusions that can be drawn from that ultimate finding of fact are that Duke was imprudent and therefore failed to meet their burden of proof. And I'd like to reserve the rest of my time.
Good morning, and may it please the Court. My name is John Rubottom, attorney for the Florida Public Service Commission. To begin with, I'd like to say that, Justice Kennedy, I think you've identified the issue at the heart of this case, which is the Commission did find that there were two causes of this outage. Now, I think it's important to point out that while the final order did and does say that the deviation from standard written procedure directly led to the outage, it does not say, nor does the discussion in the final order indicate that it was an independent cause. And in fact, the recommendation with which the Commission disagreed at the agenda conference included language that said directly and independently led. That language does not appear in the final order, and the discussion at the agenda conference is entirely about the responsibility for the outage, the causation of the outage, and one of the commissioners indeed stating that
I think, though, that you're kind of mixing things. I mean, the causation thing seems like that's not really, you know, what the issue before you guys came in, not you, I'm sorry, the company came in and said we had to buy these, you know, this replacement power. We acted prudently. We want to recover those costs, right? And so the issue before the Commission is given what was facing the company, you know, did they act prudently? And it seems like as to prudence, the only finding that in terms of what the company itself did was that they did not act prudently. And in your brief, you say that the order allowed recovery of DEF's prudently incurred costs. I don't see that in the order, and if it had said that, I don't even know how you would support that, because how does the fact that the relay broke make that a prudently incurred cost? Unless, again, it would have been prudent to rely on the relay essentially to protect you from your own errors, but the PSC didn't find that.
Our position on that is that it's true that there was no explicit statement, but the standard is costs are recoverable if prudently incurred. And so simply the granting of recovery is an indication that the Commission found that some of those costs, 50% of those costs, were prudently incurred.
But can you explain the chain of logic that would get you to that conclusion?
Certainly, we're happy to. The chain of logic is that imprudent actions, unless they give rise to and cause the outage and the cost to be incurred, is not a basis to deny recovery. So causation is implicit in this analysis. And in this case, the commission found two independent causes of the outage that, apart from either one, they are both causes in fact. They both occur in the chain of events leading to the outage. And had either one of them not occurred in this case, the outage would not have taken place. The cost would not have been incurred.
Can you point to the point of the report that says that the failure of the relay to properly work was a cause? I mean, I understand they've considered it mitigation, a factor to be considered, but I mean, it says that it was operator failure that led to the outage. And then it said, but this other thing happened that was a factor. Where does it say that that was a cause?
That the failure of the device itself was a cause?
Mm-hmm.
In the sense that it's a cause in fact, that because it failed, because it was not operating, it was a cause. It did not function as designed.
You can't say it was a sufficient cause. You might be able to say it was a necessary cause, because absent that failure, it might have, had there been no operator error, we wouldn't have known. But can you concede, I think you have to concede, that while not a sufficient cause, it is a necessary cause of what happened?
Yes, Your Honor, we do agree that at the moment the relay failed or went into a failed condition, that did not cause the outage. But in the chain of events, this operator making these decisions and actions, the reliance on the relay, that taking actions he had done in the past with no adverse consequences, in this case, there was a condition he was unaware of that led to and contributed to causing the event. So again, our position is that the causation, the fact that two causes were found, those were factors leading to the outage. That was the issue the final order was dealing with, and the commission was examining the utility's prudence with respect to those causal factors.
Well, okay. Go on.
No, go ahead.
I was just going to say, I think this takes us back to where the chief was, which is that this is a very interesting discussion about causation. Let's realize that that's only one component of the prudence determination, and that they bear the burden. And you find, I think you'd have to say that on sort of a mixed, you've got a mixed bag here. Help me understand, is it the commission's position that Duke met the prudence standard in this case? And if so, help me get over that hump, because I struggle with it.
Certainly, it is our position that Duke met its burden of proof to prove that costs were prudently incurred, and that the commission's role in that instance was to allow recovery of prudently incurred costs. And again, those facts that are discussed and summarized in the final order.
Then I guess the question then becomes, let's say that there is a basis for recovering prudently incurred costs. Why is exactly 50% of what this cost, the amount of cost that is prudently incurred, as opposed to the whole amount? Like, why? What's that about? I mean, is that really ultimately about gut?
We believe that that OPC is mischaracterizing that discussion. It is about a judgment call. It's about the commission's discretion. This ultimately is a case involving rate making. The allowance of prudently incurred costs to be recovered through rates, that's what this case is entirely about. And so when the commission is faced with evidence indicating that two combined factors led to causing the outage and the cost to be incurred, and has no indication that either one of them could have caused it on its own, the commission's position is that it's within the commission's discretion under the broad rate-making authority to grant recovery of half of those costs. It's a fair, just, and reasonable outcome under the commission's authority to set fair, just, and reasonable rates. So that's the basis for the 50% for the allocation.
Can you direct us to where we find this elaboration in your order as to the basis? Because it seems like, and this is a recurring issue, it seems to me like perhaps you can't. Like we're left with very little in the way of a record demonstrating the considered judgment that you just articulated. I'm hearing it here, oral argument, is it present on the face of any order or any conclusion?
We believe that the agenda conference, the discussion is very much about how do they determine causal responsibility. It's an entire discussion about the responsibility and how to measure it. They disagreed with staff's recommendation that there was the utility's deviation from standard procedure was the single cause. So again, it's an exercise of their discretion. It's not summarized explicitly in the order, but we don't believe that that's a basis to overrule or to remand on that basis. And I see I'm nearing the end of my allotted time, and with respect, we request that the court affirm the final order.
May it please the court, Daniel Norby and Alyssa Corey from Schutz & Bowen on behalf of Duke Energy Florida. Unless the court would prefer otherwise, I'd like to start by addressing two questions that we think are dispositive of this appeal. First, did the commission find that Duke Energy carried its burden to demonstrate prudence with respect to the CR4 outage? And two, if so, does competent substantial evidence in the record support that finding? If those two questions are answered in the affirmative, we would submit that this court need not reach any of the other esoteric issues that have been raised by the Office of Public Counsel in order to affirm the commission's order. So the first of those questions, did the commission find that Duke Energy carried its burden? You've heard from commission's counsel that that was their finding. We think that is necessarily true, even if not explicitly stated in the order. And that's because the commission outlined the burden of proof at page 28 of the record, clearly established that Duke Energy bore the burden of proof to demonstrate prudence in this appeal. And at the end of the order, the commission awarded replacement power costs to Duke Energy. It could not have done that without finding that Duke had carried its burden to demonstrate prudence.
But but I mean, in terms of the issues that were in front of them, it seems like in terms of their affirmative prudence, the only way that you would get to that is if they had said that it was reasonable to rely on the guy's past experience with not having had a problem doing it this way, and just general, faith in the reliability of the machine. That satisfied their burden, in which case it seems like the right answer is 0. But instead they basically said, it seems like they concluded that it wasn't reasonable, that they still, that the reasonable manager would have gone through the steps and done all that, in which case, the answer should be that that they should get all of it versus none of it. It just seems like those are the two options.
Well, and certainly on that issue, the amount of costs is a separate issue, I think, from the prudence determination itself. What we're suggesting is that if the commission found that Duke Energy satisfied its burden to prove to demonstrate prudence here, then is there competent substantial evidence in the record that would support that finding? We'd submit that there is. The testimony of our witness, Joseph Simpson, and the root cause analysis have abundant evidence that this was a trained operator, that he pulled this lever 1 second. If he had pulled it 1 second later, this would not have occurred. If this highly reliable relay had not failed, then this outage would not have occurred. There are a lot of things in this record, the evidence before the commission, that would support a finding of prudence here. Competent substantial evidence is a low burden here. The court's task is not to weigh the evidence on both sides, to see if there's evidence supporting that finding of prudence here. And we think that is a necessary finding here because there was an award of costs, and as you've heard from commission's counsel, the commission found that Duke had carried its burden of proof here. On the second question, though, Chief Justice, on the amount of the costs here, we don't think there's a need for the court to reach that issue and the commission's decision.
Can we back up for a second, though?
Okay.
I don't understand why we should be trying to do all these mental gymnastics that you're talking about on inferring findings when the stuff that's on the page addresses the question, and they didn't find that it was prudent to rely on that stuff.
Well, I disagree with the characterization that OPC's counsel made on that causation question. So I think that's a category confusion. Causation does not demonstrate imprudence here. proximate causation is a necessary, but it's not a sufficient finding in order to demonstrate imprudence. There are cases that we've cited in the briefs where there's no question that where a utility relies reasonably on advice that's given to them by a consultant causes an outage, but their reasonable reliance on an expert can still be prudent action, notwithstanding the causation.
Right. But the PSC is conflating causation and prudence. I mean, that's their whole argument. Is that there's two causes and therefore it's, you should only bear, I guess, this rationally arbitrary 50-50 split.
Well, there were two causes that independently would have had to come together here: the failure of a highly reliable device and human performance error by closing the circuit 1 second early. The question then is are the actions of a highly trained operator here and the failure of an equipment, does that come together to demonstrate that Duke was prudent in its actions here? We think that evidence would support a finding of prudence here. A human performance error by a highly trained operator does not demonstrate imprudence by a reasonable utility manager.
Fighting against that's fighting against what the PSC itself found. I mean, if there's one thing, how they're factoring in the machine failure the logic on that is murky. The logic on their finding of imprudence by the operator is not murky at all. They basically say, at the end of the day, you're not a bad guy, it wasn't intentional, you guys weren't, recklessly indifferent or whatever, but the bottom line is you didn't have written procedures, you didn't have training, you didn't do what you were supposed to do, and as a result of that, the outage occurred. That's crystal clear in the order.
I disagree with that as to the training aspect. The evidence was that he was a highly trained operator who made a human performance error here. What they say at page 30 of the record, what the Commission's order says, is that failure of the plant operator to follow written procedures without supervisory approval directly led to the outage at Crystal River Unit 4. It doesn't say, and therefore the conduct of the utility was imprudent. It's a causation finding, it's not an imprudence finding in our view. The second question that I wanted to get to, though, is the issue of the costs and why this Court doesn't need to reach that issue. Because if the Commission found that Duke had carried its burden as to prudence, and if competent substantial evidence supports that finding, then the aggrieved party, if there is one, as to the reduction of the cost from 14.4 to 7.2 million, is my client. My client has not challenged the cost reduction in this appeal. OPC, I don't understand to be saying that the only option here upon a finding of prudence is a 14.4 million. We've chosen in this appeal to accept the Commission's reduction in the costs, and this Court therefore does not need to reach the issue of whether it reduced those costs appropriately, whether it departed from precedent in doing so. My client would be the aggrieved party. We've not challenged it in this specific appeal, so we don't think you need to reach that question for two reasons. One is the issue of preservation that the Court addressed with my friend on the other side here. Any issues about mitigation or allocation of costs were first raised in a post-hearing motion for reconsideration that was withdrawn inexplicably without any decision on it. So I think there's a preservation issue that should prevent this Court from reaching the reduction in costs. The second issue is akin to an issue of standing here. If the costs were reduced from 14.4 to 7.2, OPC is not adversely affected by that decision within the meaning of 120.68, such that they have the ability to assert that it should have been taken from 7.2 down to 0. Again, the issue there is the reduction from a 14.4 to a 7.2. If you accept my premise at the beginning that the Commission found we had satisfied our burden as to prudence and that there is evidence in this record, notwithstanding that there might be evidence going both ways, if there is competent substantial evidence in the record supporting a prudence determination, then those are the only issues that this Court needs to reach.
Where it says that the way this went down is very troubling and does not constitute acceptable operational practices, you want us to read this as saying that you were prudent?
If the Commission had not found that we'd satisfied our burden, it would not have made an award of cost recovery here. What the Commission said, and this is the case in...
So basically, so we should just assume that regardless of the words on the page, we just should assume that that would be a bizarre standard of review, that we can ignore what you actually say and just kind of assume that you must have somehow magically properly interpreted the law to make what you did acceptable?
Well, the commission does not make any explicit finding of imprudence in this determination. They summarize the evidence, and this is something that we've seen in several commission orders, is sort of a summary of the evidence on both sides and then a decision at the end. But we think necessarily the commission found that Duke satisfied its burden of proof, or it could not have made an award of a cost recovery here. It would not have been proper to have done so in this case. We think they did find, based on the evidence before them, the evidence of the witness that the commissioner said at the agenda conference was credible, that he gave a lot of information about the specific procedures that happened here. This was a procedure that had been successful in the past. It would have been successful here, except for the failure of a device 1.5 miles away that no one could have known about. All of those factors together would support a finding that even if something happened here, a bizarre confluence of circumstances that led to this outage, that doesn't mean that a reasonable utility manager would have done something different in these circumstances. Human error is not evidence of imprudence in this setting. So there may have been evidence, and OPC has cited some evidence suggesting that certain things could have been done differently. Our root cause analysis that's in the record here suggests that some things could be done differently. But at the end of the day, the fact that these circumstances caused the outage is not in dispute here. The question is whether it was imprudent. Duke Energy was imprudent in the way that it acted here. We think the finding and the Commission's award of cost recovery here amounts to a finding that Duke carried its burden and that evidence supports that. Unless the court has further questions, we'd stand on our briefs for the remaining issues. Thank you.
Thanks.
Thank you again, and may it please the court. Speaking of raising issues for the first time on appeal, this is the first time I'm hearing about the standing issue. If I was understanding Duke's argument correctly, they were suggesting that only Duke has a right to have a problem with this case, but because of the Commission's order, customers owe just as much money because of Duke's imprudence as Duke does. Customers are being forced to pay $7.2 million, which is the same amount Duke is being forced to pay. So raising that issue is completely inappropriate.
He's just saying that the logic, and I mean, obviously, if they were prudent, why aren't they getting the? He's just saying that the logic of a prudence finding, if there was one here, that it would have led to the whole amount being recovered. I mean, so that's not a new argument.
All I was trying to say is that it sounded like a standing argument, and that would be the first time they're raising it here.
I think just what he was saying is that you're not asking for a different split. You're not asking for 70-30 or 80-20. You want all of it to Duke. And so that sending it back of should it have been 50-50 is not really something that you're asking for.
Right, correct. What we're asking for is that the Commission to be required to follow their agency practice. And it's important to remember, no party during any portion of this case contested the amount of money at stake. It was always $14.4 million. That was in the briefs, that was in the testimony, that was in the order itself acknowledges that no party contested that $14.4 million is the amount in question. And on the issue of discretion, I would point out that the Commission is stating that they're entitled to your discretion, but they're also saying that their authority to act comes from statute, from this combination of statutes. And the Florida Constitution says that when an agency acts, this court can review that action de novo. So you get to decide. You don't owe them discretion on their interpretation of their statutory authority. Additionally, both the Commission and Duke have essentially asked you to reweigh the evidence in this case. OPC is not asking you to reweigh the evidence. OPC agrees with that in sum finding that Duke's actions directly led to this outage. And as far as the conflation of causation and prudence.
Let me ask you this. Is it your position that any time an employee makes a mistake that demonstrates in which I think we admit that the employee made a mistake, that demonstrates a lack of prudence by the utility?
No, Your Honor. The prudence standard accommodates this concept of mitigation and this concept of good actions on behalf of the utility. The prudence standard says what a reasonable utility manager would do in light of
So
the
it's
facts and
conceivable
circumstances.
that if you got a redo under this, then the person who's going to be smiling is the utility, rather than the consumers.
It would be interesting to see the
Well, it
commission
would be
change
interesting.
their finding of fact, but that is conceivable. But
Well, I don't know that it would be a change. I think it would be more like a refinement.
Maybe if they're watching, they could just rewrite it along the lines of what we heard.
and we'll just have to wait and see. Stay tuned, I guess. But as far as the prudence standard, if you're to your point though, as long as the utility establishes the burden of proof that they acted prudently, whether there was an outage, whether there were replacement costs, as long as they meet their burden of proof, they will recover their money. So it's the prudence standard doesn't require the utility to prove causation. It requires the utility to prove that their actions were reasonable and prudent, regardless of whether an outage or replacement power costs are incurred. That's how this concept of fairness is already incorporated in the burden of proof, and that's why the commission should have made that finding. And ultimately, just like when we flip a switch in our houses and the power is either on or off, a utility either meets their burden of proof or they do not. Here, the commission correctly found that Duke's actions directly led to this outage. However, instead of stating, therefore, Duke's actions were imprudent and they failed to meet their burden of proof, they introduced these foreign concepts in violation of all the parties' due process rights, Duke included, because they didn't know this was going to happen. And this is fundamental error. The court should direct the commission to enter an order finding that Duke's actions were imprudent and that Duke failed to meet their burden of proof. Therefore, they are responsible for the entirety of the stipulated $14.4 million.
Thank you very much.
Thank you.
We're adjourned.
All rise.